Today our topic for discussion is powers and functions of judiciary. So my dear students, as we know that the judiciary is the third organ of the government. It has the responsibility to apply the laws to specific cases and settle all disputes. So we see that the judiciary in India, it consists of Supreme Court. Judiciary in India consists of Supreme Court, High Courts, district courts and subordinate courts So far the Supreme Court is concerned, we see that the Supreme Court is the topmost, the apex court, topmost in the hierarchy. It's the highest seat of justice, the Supreme Court of India. So we see that the Supreme Court, the highest court of appeal, it was constituted on 26th January 1950. So far the total strength of Supreme Court is concerned, we see that at the time when this Supreme Court was constituted, the strength of Supreme Court was 8 judges in 1950. So far the present strength is concerned, we see that the present strength is 34 judges, including Chief Justice of India. So far the High Courts is concerned, we see that in India the total number of High Courts 25 High Courts in India. So far the District Courts is concerned, we see that in India there are almost 672 District Courts present in India. Clear? So this judiciary, it's a watchdog of democracy. The judiciary is the third organ of the government. The main duty of judiciary is to check the validity of law. The judiciary is a protector, it's a guardian and protector of the constitution. And fundamental rights of the people. Clear? So we see that the first and the foremost function of judiciary is, to give justice to the people. To give justice to the first and foremost duty of this judiciary. The first and foremost function of judiciary is to give justice to the people. We see that whenever they may approach it. We see that the judiciary also played a role in law making. Judiciary play a role in law making. So judiciary play a role in law making. We see that the decision given by the courts really determine the nature, meaning and scope of laws. Passed by the legislature. So judiciary, it checks the validity of law. We see that the legislature, the first organ is the legislature. Second is the executive. Legislature, law-making body. Executive is the implementing agency, implement the laws. And judiciary checks the validity of law. That's why it's doing the watchdog of Indian democracy. Clear? So we see that it's the law-making. So now we see that the judiciary is a guardian. It's a guardian of fundamental rights. Guardian and custodian of fundamental rights. So far the Article 32 of which the Indian Constitution is concerned, we see that the Article 32, right to constitutional remedies, fundamental right. Article 32 is the sixth fundamental right of Indian Constitution. We see that Supreme Court of India, under Article 32 of Indian Constitution, Supreme Court of India acts as a guardian of fundamental rights of the citizens of India, and we see that the constitution can, we see that declared a law passed by, we see that the Supreme Court of India, he can declare a law passed by legislature, he can declare null and void. Passed by legislature, declare null and void. Passed by legislature, we see that under Article 32 of Indian Constitution, we see that the court declared a law passed by legislature null and void if it violates or it encroaches, we see upon the fundamental rights guaranteed by the Constitution. The Supreme Court can issue writs in the nature of habeas corpus quo warranto, mandamus, prohibition, and sorcery for the enforcement of fundamental rights. So we see that this judiciary is the highest seat of justice, and we see that as a guardian and protector of the fundamental rights as well as a guardian of the constitution. Now the jurisdiction. So far the jurisdiction is concerned, we see that jurisdiction simply means the official power to make legal decision and judgment. Jurisdiction means power to make official decisions and judgment. So far the jurisdiction of Supreme Court is concerned, we see that Article 137 to 141, it laid down the composition and jurisdiction of Supreme Court of India. So far the Article 130 is concerned. Article 137, it mentions we see that Article 137 empowers Supreme Court to review its own decisions. Supreme Court to review its own decisions. Clear? Now Article 141. So far the Article 141 is concerned. Article 41 states the law declared. Article 141. We see that judiciary is the watchdog of Indian democracy. Clear? The guardian as well as Indian judiciary consists of what? It consists of Supreme Court, High Courts, district and subordinate courts. Clear? So far now the Article 141. So far the Article 141 states the law declared by Supreme Court. Supreme Court is binding on all the courts in India. Law declared by Supreme Court is binding on all the courts of India. Clear? The jurisdiction of Supreme Court of India can broadly be categorized into three parts. First is the jurisdiction is categorized into three parts. First is the original jurisdiction. Original jurisdiction is concerned, which is under Article 131 of Indian Constitution. Article 131 of Indian Constitution, original jurisdiction covers all those cases which can originate directly in the Supreme Court. These include, we see that disputes between central and state government. First, disputes between central and state government. Disputes between state and central government. Dispute between central government and one or more states on one side and some other states on other end. Disputes between state governments. And third, we see that the cases related to violation of fundamental rights. It's the first. We see that the jurisdiction of Supreme Court is divided into three parts. First is the original jurisdiction. Second is appellate jurisdiction. So far the appellate jurisdiction is concerned, we see that Supreme Court, as we know, that is the highest court of appeal from all courts in the territory of India. We see that it hears appeals in regard to interpretation of constitution in civil cases, criminal cases, and special appeals. So applied jurisdiction, it includes the power to reverse or modify the lower court's decision. So reverse or modify lower court's decision. So Supreme, which applied jurisdiction includes the power of Supreme Court to reverse or modify the lower court decision. Which is that under this jurisdiction, the Supreme Court can transfer to itself. We see that cases from one or more high courts. If it under this jurisdiction, Supreme Court can transfer cases from one or more high courts if it involves the question of law in the interest of justice. Now the third is special appeal. As we know that Article 132 to 134, it provides for regular. We see the appeal to Supreme Court. Regular appeal is to Supreme Court from decision of High Courts. From decision of regular appeal is to Supreme Court. Regular appeal is to Supreme Court. Supreme Court from decisions of High Court. Decisions of High Court. The third is the advisory jurisdiction. Advisory jurisdiction. So we see that under, so far the advisory jurisdiction is concerned, we see that under Article 143 of Indian Constitution. Article 143 of Indian Constitution. The President of India to seek the advisory opinion, advisory opinion from the Supreme Court. From the Supreme Court in the two categories of matters. In the two categories of matters. Advisory jurisdiction में हम देखेंगे Supreme Court. The article we see that the President of India, President of India, we see that to seek the advisory opinion from Supreme Court. President, under this we see that President seek the opinion of Supreme Court, advisory opinion from Supreme Court in the two categories of matters. First, matters of public importance. First is the matters of public importance, and second, of any question arising out of pre-constitution treaty, agreement, engagement, or other similar instruments. Clear? So we see that the functions, and this was all about the functions and powers of जुडिशियरी। सो हमारे स्टूडेंट्स वीडियो को देखने के साथ साथ चैनल को सब्सक्राइब करना ना भूलें।